All right. Good morning, everyone. Court will resume with the November 29th, 2022 docket. We're on YouTube here. And I first have here P0362-20-4, Magda Gutierrez versus Joe Daniel Berrones.
Good morning, Judge. Cindy Esquivel for the state and the applicant.
Yes, ma'am. Good morning. And good morning, Mr. Barber. Yeah, he needs to unmute. All right, Mr. Bravo. There you go.
I am present, Your Honor. And
now I can hear. I have a hard time reading lips, but I know more or less what you're saying, but I really don't fully understand it. What do we have here, Ms. Esquivel?
Yes, Judge. Judge, today we're here to request an extension of the ex parte and a contested hearing date solely on the matter for child visitation. We couldn't reach an agreement, Judge.
Okay. So you want to...
Judge, just for the record,
yes,
we asked you for like a 3 or 4 month reset. Mr. Berrones is in custody, and he should be hopefully released by the next hearing date.
Okay. To be an extension?
Yes, sir.
February 9th. February 8th at 9 a.m.
February the 8th, 9 a.m. February the 8th, 9 a.m.
If he's released before.
Of course, if he's released before and you need action from the court, please let us know. We'll bump it up. Okay.
Thank you, Judge.
Yes, ma'am. Now we have another one, right? It's P 0392-21-4. Juana Tames versus Abel Tames.
Yes, Judge. I believe it's Juana Villafana.
Yes.
Judge Cindy Esquivel for the state and the applicant. I believe opposing counsel is put in contact with the respondent in this case.
And Judge, on this case, I believe there's also an agreement to reset it. There had been an issue in terms of finding him, locating him. He had originally been appointed. Well, the case had already been pending for a while, but I've had some difficulties finding him. So I believe it's an agreement for about 3 or 4 month reset.
Okay. Same date, February the 8th, 9 a.m. February the 8th, 9 a.m. Of course, if you need the court to bump it up, let us know.
Will do.
Thank you, Judge.
Okay. All right, then. Thank you very much. You both may be excused. Happy holidays.
Thank you, Judge. You all
Thank you.
I do have another matter, Judge. Number 3.
Number 3.
We're waiting for the attorney, Abel Hinojosa.
Okay. Yeah, I'm waiting for Abel Hinojosa. And who else is supposed to show up in this one?
Nereida's already in the waiting room.
Okay. It'll be Nereida and Abel.
Abel called that he's coming from Cameron County.
All right. Abel is coming from Cameron County. All right. We'll call that one. Okay, man.
Thank you, Judge.
Thank you. All right. Who are we going to get next?
I have Roby and Tim Davis.
Okay.
On Corbett.
Okay. All right, I see Mr. Flores already on the screen there, and Mr. Davis. All right, there they are, Mr. Roby Flores and Mr. Timothy Davis. Now, I believe we're here on F6902-18-4 in the matter of the marriage of Corbett and Corbett.
Yes, Your Honor. Roby Flores on behalf of Ms. Yada Corbett.
Tim Davis on behalf of Mark Corbett.
All right, gentlemen, what do we have here?
Judge, we're here on a motion for entry of our decree. We had a Rule 11 agreement. Just by refreshing the court's recollection, we had a Rule 11 agreement that we filed with the court. It was e-filed back on 9/26. We then proved it up. And Mr. Corbett didn't appear at that hearing. We submitted the decree to Mr. Davis. He requested some changes in the name of the husband's company. We did that, and there was a couple of other things that we changed. However, my understanding, they want to change the times of the pickup and drop-offs that aren't reflected in the Rule 11 agreement and aren't reflected in the code as per the code that's reflected in the Rule 11 agreement. So the decree that we have submitted to the court shows his pickup time pursuant to the Rule 11 agreement at 6 p.m. and he keeps them through Monday when school starts. On Thursdays at 6 p.m. pursuant to the Rule 11 agreement, and picks up Friday when school returns Friday morning when school commences. And then obviously if it's his weekend, he picks up on Fridays at 6. The spring break is as per the code, and so are the holidays. And that's what our Rule 11 agreement said.
Uh-huh.
Our Rule 11 agreement said, if you read on page 1, it talks about the first, third, and fifth commencing at 6, Thursdays commencing at 6, and holidays as per the code. The decree that we submitted has the holidays as per the code per section 153.314 and his spring break provision as pursuant to 153.312. They're wanting to change it to when school lets out. That wasn't our agreement. Well, believe me, my client wanted more child support, but that wasn't her agreement. She accepted less child support.
Mhm.
So those are the objections as I understand them. And if the court will share a screen with me, I can show the court the statute and the Rule 11 agreement.
Okay, but there's no objection regarding the holidays or spring break, so. I'm not-
So what do you object to?
Well, whenever you're finished, I'll address my objection.
If the court can give me a screen, Judge, can I share a screen?
Okay.
It's ready.
I think it's ready.
Okay, in the Rule 11 agreement that was filed with the court, that was signed by Mr. Davis and I, we showed the pickup and drop off on the first and fifth Friday, commencing at 6 p.m.
Until Monday.
Monday morning.
Uh-huh.
And the same is true for Thursday. And that's what's reflected in the decree.
Mhm.
They're not objecting to the holidays or spring break, then I don't need to talk about that.
Mhm.
The summer possession, we made the correction. They had a complaint about the spring break. We corrected that spring break issue to comply with the code. And the holiday, the summer possession, they wanted a correction, and we corrected that so it reflects what the intent of the Rule 11 agreement was.
Mhm.
And other than that, that's my understanding of the objection. And I had brought this statute out because they had told me about the holidays, but if you will see, holidays is unaffected by distance, and it starts, if you can see the arrow, they begin at 6 p.m. And on the 28th, it ends at noon, and then ends on 6 p.m. on the back end. And the same is true with Thanksgiving. Thanksgiving began at 6 p.m. and end at 6 p.m. And that's what the decree reflects. Mother's Day and Father's Day, I don't think got all that corrected. So unless I have misunderstood their letter, they haven't filed any formal objection to our decree other than sending me a letter. So we're asking the court to sign the decree that was e-filed with the court today that reflects the Rule 11 agreement and that was rendered in the court.
Yes, Judge.
Yes, sir, Mr. Davis.
There's several issues with the proposed decree, and I've, since the middle of October, brought them to Mr. Flota's attention. The first one is my client was awarded his company, and I've told Mr. Flotas the name of his company is MDC Engineering, PLLC. That still hasn't been reflected in the decree. Under on page 22 of the submitted decree, under H7, Mr. Flota's client is supposed to tender to my client $86,575.50. As per the mediated settlement agreement, it was within 120 days of the mediated settlement agreement. They keep putting it in the decree as 180 days. And I brought that up, but they haven't made the change, even though it's reflected right there in the Rule 11 agreement. Also,
Hold on, so we can take it one at a time. I agree that I see the Rule 11 says 120.
It's 120, okay?
I'm making that note on the decree so I can change that. On the
Okay,
NBC, I put NBC, but I think he's now wanting me to put LLC engineering.
PLLC.
NBC, comma, PLLC
Correct.
engineering, or just
No,
PLLC?
no, it's MDC Engineering, comma, PLLC.
Fine, Judge. I'm making that handwritten note. I'll change it right now.
okay,
Also, I asked that the decree include a paragraph or point H9, which was where Mr. Corbett was pursuant to the mediated settlement agreement, was awarded all his clothing, other
First of all,
personal
it's a Rule
effects.
11. First of all, it's a Rule 11, not a mediated settlement agreement. that was-
I'm sorry, yeah.
But go ahead.
Rule 11, he was awarded, the agreement was he would get all his clothing, jewelry, and other personal effects located at the 1321 McKee Drive in Edinburgh. That hasn't been included in the decree. It was part of the parties' agreement.
Hold on, Judge. Let me just look here. It says any and all personal property in his possession.
Well,
And
that,
that's on page 2 of the Rule 11. Can you tell me? Where is it? You said it was in the Rule 11. I'm trying to see where it says that. I think I sent you a letter, though, if you had some personal items to identify it.
and I did, and we sent you a good list and we got no response. Okay, right here,
Right. And so you're okay with the list they sent? I mean, it's been 5 years, Tim. I mean, whatever on that list, if she has it, she'll give it to him. We don't have a problem with that.
well, he needs to be able to go pick it up. That's what we'd ask as well. Because he also needs to get the vehicles. Now, Judge, with regard to the visitation, on page 1 of the Rule 11 agreement, it says Mark Corbett extended standard visitation. The parties live within 50 miles of each other, and it was always his intent that he would have extended standard visitation. Under 153, 31.7, and 31.7.1, that's where that's set out. So unless he makes an election, either in open court or in writing to the court, his visitations begin when school gets out on Thursday. And then in his off weeks, the weeks where he doesn't have the first, third, and fifth, he would have the kids from the time school's dismissed, and he would take them back to school Friday morning. This is during the school year.
Yeah, Judge, but that wasn't the agreement. If you look at the Rule
But the
11,
agreement, right, but the problem is
the Rule 11 agreement specified the time that was signed off with his lawyer's authority that the commencement time would have been at 6 p.m. The negotiating was being done here. Trust me, Judge, that's like me saying, Miss Corbett is going to get X amount of dollars of child support, even though she was receiving $2,500 before, and she really wants the $2,500 because we believe that's really his statutory obligation, but she decided to take less. So never mind about this $12,50, Judge. Go ahead and bump it up to $2,500 because that was my intent. No, this was our agreement. My client conceded things and his client conceded things, and what they conceded was the start time being at 6 p.m. on Fridays and on Thursdays, period. Not I'm going to get to elect later, not that I'm going to make some other decision. This was the agreement, and they want to go outside of this agreement now.
no, we want to go by the Texas Family Code.
Well, and we did too on child support, Judge, but we didn't.
So, but Judge, at the end of the day, here's the way it's set out on my client's first, third, and fifth weekends. He would have to pick the children up at 6 p.m. at his ex-wife's house, take them to school the next Friday morning. Then they would go home to mom's house, and he has to go back and pick them up on Friday at 6, and then have them until Monday morning, instead of just from Thursday through Monday morning.
But believe me, we understood that. And my client knew what she was negotiating. And she wanted to see her children after school on Fridays till 6 p.m. That's why she authorized me to enter this agreement. That's why Mr. Corbett entered this agreement. We don't get to cut and fish bait after the agreement has been approved and proved up, Judge. We proved it up on the record pursuant to this Rule 11 agreement. And he didn't make the election then either, because he knew what he agreed to.
Because the election is for, the election he would make would be for what you want.
And
That's
this is where he signed off on it.
Okay. All right. What other objection?
That's all, Judge.
Okay. First of all, the name change. You got that right, Mr. Flores?
Yes, I'm doing it in the decree as we speak, because I want to send this over
The
to
exact name of that company
Yes, sir.
with the PLLC, and then on the 180, that's going to be changed to 120, right?
I got it. I'm doing that as we speak.
All right. And then what was the next thing? All the personal items. The list. You're going to include the list also?
I
All
still
personal items?
what is the list?
What I'm going to put in the decree, I mean, and I want to word it right now, Judge, because I don't want to come back again. Let me get the decree up.
Okay.
Give me 1 second.
I just suggested it be H9 on page 22.
H9, page 22
Yes, sir. We need to add that.
of the decree.
Yes, sir.
Okay.
Hold
Can
on,
you
Judge.
put that up, Mr. Flores?
I'm going to share the screen and put it up here,
All right.
and I'm going to go to
Page 22, H9.
So see
All
that
right.
it ends with H8. So I was
Right.
we need
You
to
want to add H9, and that'll be what's on the list, right?
all personal property that can be located by Miss Corbett.
No, that's not.
Well, the judge. Well, Judge,
Can be
here's
located.
the
Will be
problem, Judge.
located.
Well, look, Judge, here's the problem. It's been 5 years. If he says he's looking for a wrench,
Judge, my client's here and he can speak to it. And then some of these things are family things from his father, tools, hunting equipment, fishing. I mean, this is not
No fishing gear on the list.
there is no fish. There is no fishing gear on that list. Tim is speaking out of turn.
Right.
And now and on the list are tools. You know, I'm not going to pin down my client. Oh, she forgot to turn over a screwdriver that I know was there. Well,
we're not in Robbie, but we're not asking her to turn anything over. Just let him go over there for
No, Judge. We're not going to let him come. We didn't go rummage through his house about things that he took that she may have wanted back. We have the list. She will produce any and all those items that she can find there at the residence. And if they're not there, I can't have her magically appear something that doesn't exist. Or he may.
To where will she produce them and by when?
He can come by to pick them up. That's all permanently located located at, what's the address?
1321 McKee Drive in Edinburgh.
1321 McKay Drive.
Right.
Okay, Edinburgh.
Edinburgh.
Okay.
All personal property of you said personal nature, Tim?
I'd use the term clothing, jewelry, and other personal effects. And then I sent you the list. I think
All personal clothing,
jewelry, and other personal effects.
Clothing, jewelry.
personal
And other-
effects is too broad, Judge. That's my chair. This is my sofa.
No, it's not furniture or appliances. I mean, I've already made you the list. You can make a,
Personal jewelry,
And personal items?
and items on list that can be located shall be tendered to him at the residence. Pick a day.
Mark, are you there?
Yes, I'm here.
What's a good day that you can go pick everything up on your list?
Yeah, Friday, how about Monday the 5th?
Well, if she's gonna look for these things, hold on. Let me just look at a calendar. Give me a second. How about December the 10th? That's on a Saturday. That way,
No, I can't do December 10th. But how about during the week sometime, not a Friday?
I'm trying to pick a Saturday so it doesn't interfere with anybody's work or kids' schedule.
Well, I mean, the kids are not involved in this.
Well, they're at the house.
They're
at school.
They're at school during this
Right,
time.
so what day?
Yeah, I had offered up the 5th, 6th, 7th.
She can't do the 5th. My client's here.
12 through
So give me a
15th,
date.
12th through 15th, any of those days, 5th through 8th, any of those days, 19th through 22nd. I mean,
December 5th?
and I do take exception with the can be located because we provided an exact list. And by the way, there is no jewelry. I don't have any jewelry over there.
Well, that's what I thought, but your lawyer said there was jewelry.
Well, but Roby, you've had the list since October, sir.
Judge, I'd rather address myself to the court and to Mr. Davis. What day? Give
Very
me a
well.
day.
Very well. I'll go on mute again.
Give me a date. How's December the 8th?
Yes, he had said any 5th or 8th are good.
Yes.
December 8th, 2022 at 6 p.m. He's going to be there anyway.
It'll be 6 p.m.
Whoa, wait, not 6 p.m. because I pick up the children. How am I supposed to pick up the children and then haul a bunch of stuff back at the same time? Come on, let's be logical about this. Can we do it at noon? Can we do it at noon?
No, she works. How about at 5:30? That gives you 30 minutes to load whatever you're loading.
Yeah, and then I'm supposed to return and get the kids at 6 o'clock by 5:30, which goes back to what we're talking about with it anyways.
No,
So I'm trying to offer up a solution.
I'm giving you one. Just
How about not the time when I'm picking up the children and at least not 2 hours before? That way I have time to take the stuff.
How about December 7th, the day before?
Yes, absolutely.
How about December the 11th? That's a Sunday.
6 o'clock, December the 7th. I cannot do the weekend.
Why?
I cannot do that weekend.
Well, I'll leave everything up. December 11th at 6 p.m. until Monday.
She'll be happy to leave everything on the porch on December 11th, and that way when he finds time to go do it, he can go do it, Judge.
Really, come on, guys. I'm offering you 5th through 8th, 12th through 15th, 19th through 22nd, 26th through 29th, any of those days except 2 hours before I pick up the kids, at least give me some time to unload. Come on. I mean, please be reasonable with me here.
I'm trying to pick a day when he doesn't work, Judge, and my client doesn't work. I'm offering up December the 11th. It's a Sunday.
I'm willing to make time to get this done.
Right, December the 11th. Pick a time.
No, I told you it's not going to be on the weekend, Roby.
He won't be.
I'm telling you, I cannot commit to that weekend.
He's not in possession of the kids that weekend, Judge. I mean, it doesn't interfere with his possession.
Yeah, you know what?
He's offered you almost every week.
That won't work. But
Is
I'm
that-
offering up
He
almost.
said the
half a
5th
month.
through the 8th, the 12th through the 15th.
How about the 18th? That's a Sunday. How
No,
about the 20th, December 20th? It's a
Yes,
Tuesday.
December 20th. Great. Let's
Perfect.
do that. Wait, what is December 20th? Do I have the children then?
that's
It's
a Tuesday.
That's fine. December 20th. Let's do that.
All right, December 20th.
At 6 p.m.
Just work with me, guys.
6 p.m.
6 p.m. or 5 p.m.
5 p.m. is fine.
What time?
5.
Let's do 5, so it's still light a little bit.
When there's a little light, at least.
Still daylight
gets
at
out of
5,
work
right?
at 5.
I know.
Let's compromise 5:30. Let's between 5 and
Yeah,
6.
at least there will be a little light left to work. Yeah.
A little bit of
All right.
light. So, okay, 5:30,
Okay, 5:30.
5:30.
Now let me go back over here, Judge. ELLC. And then
No,
That's
it's
MDC Engineering.
Engineering PLC.
MDC Engineering.
Right. That's not how you spell engineering.
Is that correct now?
No, engineering is spelled with 2 E's and 1 R.
There you go. All right. Are we done?
But we're still objecting to the visitation schedule.
But the schedule, that's the one we know right now. That's the Rule 11.
Yes, sir.
Right, it's supposed to be the extended standard visitation.
Well, that's our Rule 11, Judge. It starts at 6 p.m. That's what they agreed to. That's what my client agreed to.
Okay. When we had the hearing, that everybody showed up and we had the final hearing, what was said at the hearing?
And it was following the Rule 11,
Okay.
and Mr. Corbett did not appear.
I was there.
Yes, but
Okay.
well, yes, and he was here when he signed the Rule 11. That's the
Yeah.
point.
Okay.
He has the
Okay. It'll be
authority.
the Rule 11.
All right,
What else?
that's it, Judge. I'll e-file that with the court right now.
Would that be an amended one? Because he filed one already.
Yes.
Yeah, there's a light.
It'll be amended.
Wow.
It'll be amended, Ruby, because you
Want me
already
to call it
submitted,
amended?
because you already submitted one, right?
Well, we submitted one, but it hasn't been signed. You can reject it.
No, because it's already there, then it's gonna be confusing.
All right, no problem.
It's gonna be amended.
Yes.
I'll put amended.
It'll be amended. All right. Anything else, gentlemen?
No, sir, that's all.
All right. Thank you very much. Your excuse. Have a great holiday.
Thank you, Judge.
Thank you.
Have a
Bye-bye.
good one.
Next.
Number 1.
Number 1. F-2471-22-4 in the matter of the marriage of Oralia Vasquez and Isaías Vasquez.
Good morning, Your Honor. Diana Fuentes Aguilar for Isaías Vasquez.
Yes, good morning. Mr. Barrera, can you?
Good morning, Your
sir.
Honor.
Yes, sir.
Rick
Good
Barrera.
morning. Yes. And what do we have here? It's the final hearing?
Have an agreement. Mediated.
It is a final hearing. It's been successfully mediated, Your Honor. It is a divorce. We have a short prove up.
All right. Who's going to be testifying? Ms. Vasquez?
I have Ms. Vasquez. I just want to confirm she's on Zoom right now. Yes, she is.
All right. Good morning, ma'am. Can you hear me?
Yes, I can. Good morning.
All right. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may put your hand down and you may get it started. Mr. Barrera?
Thank you, May. Please, the honorable court. Ms.
Yes, sir.
Vasquez, please state your full name.
Oralia Vasquez?
Now, Ms. Vasquez, your husband has resided in Hidalgo County 6 months before the filing of this petition for divorce. Is that correct?
Yes, that is correct.
And the marriage to me is becoming supportable because of discord or conflict of personalities. There's no expectation you're going to get back together. Is that correct?
Correct.
There currently are no minor children, no children expected, and no children were adopted. Is that correct?
Correct.
And you have come to a full and final settlement that you deem just and right in the form of a mediated settlement agreement that you in fact signed. Is that
Yes.
correct?
Yes, it is.
And during that mediated settlement, I was there to answer all your questions. And at the end, you signed it knowing that you understood what was going on and you made a full disclosure of all property in the case. Is that correct?
Correct.
You're asking the court to grant your divorce and to incorporate the terms of the mediated settlement agreement into the divorce decree. And the terms with the settlement agreement would be superior to any conflicting language in the order. Is that correct?
Yes, correct.
Your Honor, I pass the witness.
All right, Ms. Aguilar.
I have no questions, Your Honor.
Okay, very well. Anything else?
No, Your Honor.
Well, then, court will take judicial notice of the entire file in F 2471-22-4. In the matter of the marriage of Auralia Vasquez and Isaias Rubio Vasquez, court will hereby approve the agreement of the parties. Court will go ahead and dissolve the marriage of petition respondent. Court will await a final decree for signature. Anything else, folks?
No,
Thank you for your time, Your Honor.
Thank you all very much. Happy holidays. Stay safe.
Same to you.
Bye-bye.
Thank you.
Waiting for attorney Nereida Singletary and Abel Hinojosa on number 3.
Okay, waiting for Nereida Singletary and Abel Hinojosa on cause number P0218-22-4.
Take a recess.
Take a short recess. You want to be on YouTube? All right, now court will resume with the November 29th, 2022 docket. And we have P0218-22-4. It'll be
She might have an announcement.
Hernandez versus Hernandez. Yes, Mrs. Esquivel, good morning, ma'am.
Good morning, Judge. I did speak to Mr. Hinojosa's office, and I don't think that he's gonna be able to come, but we did have an agreement to extend after the mediation date that they have set for the divorce. I believe it's set for December 5th, Judge.
To extend,
Yes, extend the ex parte for a date after December 5th, which is when they're supposed to go into mediation on the
January
divorce.
23rd.
okay, after December 5th, right?
Yes, Judge.
I'm sorry. no,
January 23rd at 11 a.m.
Let's do January 23rd at 11 a.m.
Thank you, Judge.
And once again, if there something comes up that you all need the court to bump it up or something, just let us know. We'll try to work with you, okay?
Yes, Judge. That's all I have before this honorable court. May I be excused, Judge?
Yes, ma'am, you're excused. Have a good day.